Thank you, Madam President. Madam President, question number 118 to the Minister of Public Utilities.
Minister of Public Utilities.
Thank you very much, Madam President. Madam President, WASA is an essential service in Trinidad and Tobago, and as such, any security arrangements concerning the operations of the authority or that of its offices and/or officers will not and should not be disclosed in the public domain. I wish to add, Madam President, that any premature or untimely disclosure would compromise any security arrangements that are already in place or will be put in place in the near future.
Senator Mark.
Madam President, if the Minister can outline the law in Trinidad and Tobago that prohibits him as Honorable Minister from disclosing the procurement of services of a private security firm to protect the assets of the authority, I would ask him to share that section of the law so that the population can be aware.
Senator Mark, I won't allow that question.
Can the Minister indicate whether his office was involved directly in this procurement process? Can the Minister indicate whether his office was directly involved in the procurement of these services by this private security firm?
Minister.
Madam President, the procurement of security services in the Water and Sewage Authority was procured in accordance with the tender rules of the Water and Sewage Authority.
Can the Minister indicate, Madam President, whether this particular private security firm was procured on the insistence of the Office of the Minister of Public Utilities? Can the Minister share with this House whether that is in fact so?
Senator Mark, I won't allow that question.
Madam President, can the Minister indicate whether the procedure to procure private security services for the Office of the Minister was in violation of the procurement laws governing WASA tendering procedures?
Senator Mark, I won't allow that question. Next question, Senator Mark.
Thank you, Madam President. Madam President, question 119, that is 119, to the Minister of Public Utilities.
Minister of Public Utilities.
Thank you very much, Madam President. Madam President, the Water and Sewage Authority has not engaged in any retrenchment exercise concerning its employees.
Senator Mark.
Can I ask the Honorable Minister, in light of the transformation plan of WASA, whether the government is about to embark in the near future or imminently the retrenchment of any contract workers engaged with the Water and Sewage Authority?
Senator Mark, that question does not arise.
Madam President, can the Minister categorically state for purposes of this House that the Water and Sewage Authority will not be embarking on any retrenchment of contract workers?
Senator Mark, that question is not allowed.
So can I ask the Minister through you whether the Minister and WASA will be meeting with the relevant trade unions with a view to restructuring WASA, particularly as it relates to the severing of workers? Madam President?
Senator Mark, that question does not arise.
Do I have any further?
You have one more.
Madam President, I would like to ask the Minister whether, for instance, there is any intention on the part of the government to sever any persons who are in the employ of the authority in the coming period.
That question also does not arise. So can we move on to the next question?
Can I ask the third question now, Madam President? Question 120, I believe.
Yes.
To the Minister of Energy and Energy Industries.
Thank you very much. When an accident or incident occurs within the energy sector of the Ministry of Energy and Energy Industries, they would immediately conduct an investigation. When an accident or incident occurs within the energy sector, the Ministry of Energy and Energy Industries would independently conduct an investigation to determine the root cause of the accident. A team of suitable technical officers would be established to conduct the investigation. The team is tasked with establishing the facts, inclusive of getting the background information on the job, the work assignment, the job events leading up to the accident, determination of the root causes and contributing causes of the accident. The process involves full information gathering, site inspection, conduct of interviews and obtaining witness statements, accident cause identification, and where appropriate, review of the reports of relevant statutory agencies. And on completion of the investigation, the Ministry of Energy and Energy Industries prepares an accident report which provides an account of the accident together with recommendations that can reduce risk and prevent a recurrence. Thank you.
Senator Mark.
Madam President, can I ask the Honourable Minister, in the case of the situation involving the 4 dead divers, involving those divers, can the Minister indicate prior to the appointment of members to head a commission of inquiry whether this independent committee, as outlined by the Minister, was indeed appointed by the Ministry of Energy and Energy Industries?
Minister.
Senator Mark, you asked a very general question to which I answered in kind. Thank you.
Specific question now, seeing that it was general. Can you indicate to this Honorable Senate whether the independent committee that the ministry normally would have appointed in the instance of the Paria incident or accident was an independent committee appointed? That is the specific question.
Minister.
That may be the specific question, but as I said, you asked a general question, and I'm keeping my confines to the question asked. You may pose another question.
Senator Mark.
Madam President, is the Minister indicating to this Honourable House through you that no independent committee was appointed by the Ministry of Energy and Energy Industry consistent with its procedures whenever an accident occurs in the industry? Is the Minister admitting that no independent committee was appointed? Can I ask the Minister, through you, Madam President,
Senator
to clear
Mark,
the air on
yes,
this?
I heard the question, but that question is not allowed.
Madam President, can the Minister give an undertaking to report to this Honourable Senate whether the Ministry indeed appointed an independent committee to look into the circumstances surrounding the deaths of these 4 divers in the Paria accident, Madam President?
Senator Mark, that question is not allowed.
Madam President?
I think you've used up your. You have.
I was just on the third one, ma'am.
Yeah. So Next question.
I don't have any
Senator
more.
Richards.
Question number 185 to the Prime Minister.
Acting Leader of Government Business.
Thank you very much, Madam President. Madam President, the package of children's legislation, which included the Children's Authority Act, the Children's Community Residences and Foster Care and Nurseries Act, the Children Act, and the Adoption of Children Act, was proclaimed in May 2015 to enable the operationalization of a new child protection system in Trinidad and Tobago to be managed by the Children's Authority. The Children's Community Residences, Foster Care and Nurseries Act, hereinafter the Act, set out a regulatory framework for community residences, which is essentially a licensing and monitoring regime. Section 3.1, as amended, prohibits a person from operating a children's home without a residence license, while Section 3.2, as amended, provides that no child shall be cared for in a children's home unless a residence license has been issued in respect of that home. Section 17 establishes an offence for operating a children's home without a residence license or for a breach of the conditions of the license and sets out the penalties for the offence. In order to be issued a residence license by the Children's Authority, children's homes must meet the standards prescribed in the regulations. And these standards were first prescribed in the Children's Community Residences Regulations 2014, which has been replaced by the much more comprehensive Children's Community Residences, Children's Homes Regulations 2018. The standards prescribed in the regulations address a range of issues related to, inter alia, the premises, the welfare of the children in the homes, safety and security, the keeping of records, and a complaint system. Each standard is measured against benchmarks, which must also be satisfied before a license can be issued. At the time of proclamation of the package of children's legislation in May 2015, the residential childcare sector was unregulated. As such, many of the homes needed time and assistance in order to become fully compliant with the licensing requirements. And to facilitate this and to avoid the displacement of a significant number of children, the sections have not been proclaimed. Nevertheless, the Children's Authority has worked assiduously to enable many homes to achieve licensing status, and to date, 18 homes have been licensed. However, it is important to note that since it commenced operations, the Children's Authority has been carrying out its monitoring function and has been monitoring both licensed and unlicensed homes to ensure the well-being of the children resident in these homes. Section 17 creates an offence for operating a community residence without a license and is therefore linked to subsections 1 and 2 of Section 3. Hence, it will be proclaimed together with these two subsections. A proposed time frame for proclamation has been determined as March 2023. This projection is made based on the need for careful consideration of a few mitigating circumstances prior to the proclamation of the sector. On the one hand, if the proclamation is made too soon, a large number of children will be immediately displaced. An estimated total of 310 children may be immediately displaced. On the other hand, the total capacity, if already overburdened, children's residences accommodation will also be reduced by 383 places. It is therefore recognized that there is need to give community residences some additional months to become fully compliant and to meet licensing requirements. The Office of the Prime Minister, Gender and Child Affairs Division will also need additional time to provide the needed support to the unlicensed children's homes as far as possible to ensure that they achieve compliance. Thank you.
Senator Richards.
Thank you for the comprehensive answer, Minister. Can the Minister indicated 18 homes are presently licensed, have met compliance requirements. Can the Minister indicate how many homes under the radar of the Office of the Prime Minister have not been licensed?
Minister.
13 private. There are 13 private unlicensed homes. Private ones. In addition, the state homes, St. Dominic's, St. Mary's, and St. Jude's are also unlicensed. Unlicensed, sorry.
Senator Richards.
Thank you. Can the minister indicate if the OPM has put additional monitoring systems in place for the unlicensed homes identified, given the fact that they clearly have not met compliance standards and are yet to be licensed?
I can give you the assurance that there are monthly monitoring mechanisms in place. They do monitor monthly. However, they do in fact do more than that to ensure that they can get the homes up to the standard that is required. But of course, there's no fixed schedule, and understandably so. But every effort is being made, and with additional monitoring as is necessary.
I have one more, Madam President.
Sorry?
I have one more question in this regard.
You have two more.
Two more. I just have one more question. Can the minister indicate then if the OPM is comfortable with the care being given to children at these homes? Sorry.
What? I'm sorry, repeat. Could you repeat?
Can the minister indicate if the Office of the Prime Minister is comfortable with the safety requirements being met and the safety of the children at these 13 homes?
Senator Richards, I won't allow that question.
Thank you. Can I move to the next question, Madam President?
Yes.
Question number 186.
Sure. No, I'll call on Senator Naked after. It's fine. You can ask your question.
Yeah, Madam Chair, through you, Madam President, I'd like to ask the Honorable Minister, when does the government intend to proclaim the relevant section of the Act so that licensed or unlicensed homes can come under the jurisdiction of the licensing authority? Can you tell us, Honorable Senate, is there a time frame for that process to take place?
Senator Mark, I believe that was contained in the answer given by the minister.
It was?
Yes.
I didn't hear it. Sorry, but I'm guided by you. Okay.
Senator Naked.
Thank you, Madam President. I'd just like to ask the minister. She mentioned several names, schools there that are in the system for decades. I would just like her to give some clarity why the government has not addressed their licensing until now. She mentioned St. Dominic's and other schools in the system for decades.
Minister.
I can give you the assurance that government is making every effort to ensure, and again, to put everything in place to ensure that all of the children's homes, whether private or state, are brought up to standard, and that the full proclamation done, as I said before, by March 2023.
Next question, Senator Richards.
Thank you, Madam President. Question number 186 to the Prime Minister.
Acting Leader of Government Business.
Thank you, Madam President. In instances where there are reports of abuse in children's residences or homes, the children identified are provided with counseling by the staff within the welfare department at their home. When there is no welfare department, the child is seen by a psychologist from the authority or referred to an external provider. In instances, to part two of your question, in instances where the allegations of abuse are related to staff, it is the practice to send persons on leave pending the outcome of the investigation. However, in one instance, pending the outcome of the investigatory process, the employee against whom abuse was alleged relative to a child has been placed in a section that does not deal with children. With regard to part three, the authority is continuing to monitor the observance of the care protocols of the homes to ensure that care standards are maintained. There are benchmarks or standards which are used to determine the standard of care being provided by the homes. They are utilized during the monitoring visits conducted by the licensing and monitoring unit. And at the end of each visit to the homes, they are informed of any non-conformance which have been observed and the need for remedying same. In such instances, and based on the type of non-conformance, the authority may work with the homes to help them attain that standard of care. Where there are allegations of abuse, an investigation is conducted and recommendations for actions made to the homes. Thank you.
Senator
Madam.
Richards?
Yes, Madam President, thank you. The Minister indicated that one person has been transferred to an area that is not in contact with children, and that the practice has been to suspend persons pending the outcome of the investigation. Can the Minister confirm that all persons who had been identified as being alleged to be involved in abuses have been removed or suspended?
What I can confirm to you is that, as I said in my question, in the response, there is one instance in which, in a particular facility, where one member of staff was moved from a children's ward to an adult ward, and that was at the Lady Ho Choi home. And that matter is still under police investigation.
Senator Richards?
Yes, Madam President, thank you. And no more questions, Madam President.
Introduction of bills, the Bail Amendment, Extension of Duration Bill 2022. On the supplemental order paper, the Private Security Industry Bill 2022 in the name of the Minister of National Security, and the Supplemental Police Amendment Bill 2022 in the name of the Minister of National Security.
Attorney General.
President, in accordance with Standing Order 62(1)B, I beg to move that the next stage of the Bail Amendment, Extension of Duration Bill 2022 be taken on Monday, July 4th, 2022.
Honourable Senators, the question is that the next stage of the Bail Amendment, Extension of Duration Bill 2022 be taken on Monday, July the 4th, 2022. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The next stage of the Bail Amendment, Extension of Duration Bill 2022 will be taken on Monday, July the 4th, 2022.
Motions relating to the business or sittings of the Senate and moved by a minister.
Acting Leader of Government Business.
Madam President, pursuant to the motion approved in the Senate on February 22nd, 2022, I beg to move that a special select committee be established to consider and report on a code of ethical conduct and behavior for senators by Friday, July 8th, 2022, and that the following senators be appointed to serve on the committee: Ms. Christine Kangaloo, Chairman; Ms. Paula Gopi-Schoon, Member; Dr. Mohammed Ibrahim, Member; Mr. Anthony Vera, Member.
Honourable Senators, the question is that a special select committee be established to consider and report on a code of ethical conduct and behavior for senators by Friday, July the 8th, 2022, and that the following senators be appointed to serve on the committee: Ms. Christine Kangaloo, Chairman; Ms. Paula Gopi-Schoon, Member; Dr. Mohammed Ibrahim, Member; Mr. Anthony Vera, Member. Those in favour say aye. Those against say no. I think the ayes have it. Acting Leader of Government Business.
Madam President, may I ask a question? I'm a little bit confused about something. Under item 13, introduction of bills, there were 3 bills to be introduced. Did I hear one, or did you read all 3?
All 3 were read.
Sorry for that temporary lapse in judgment.
Acting Leader of Government Business.
Madam President, I've been in contact with the leader and coordinator of the benches opposite, and as a result, I wish to indicate that in accordance with Standing Order 117, an agreement was reached in relation to today's Senate proceedings. The benches agreed that, having a regard to the nationwide tropical cyclone number 2 warning released by the Trinidad and Tobago Meteorological Service, that today's sitting should be concluded no later than 4:30 p.m.
Honourable Senators, in accordance with Standing Order 117, I wish to announce that an agreement was reached among the benches that, having regard to the nationwide tropical cyclone number 2 warning released by the Trinidad and Tobago Meteorological Service, that today's sitting should be concluded no later than 4:30 p.m.
Public business, private members' business, motions.
Honourable members, the debate on the following motion, which was in progress when the Senate adjourned on Tuesday, May the 25th, 2022, will be resumed. Be it resolved that this Senate agree that the Caribbean Court of Justice be recognized as the final court of appeal for Trinidad and Tobago. and that the appropriate amendments be made to alter the Constitution of Trinidad and Tobago so as to entrench the court as its final court of appeal. There have already been 6 speakers on this motion, including the mover of the motion. Senator Dylan Remy. Senator Dylan Remy.
Thank you, Madam President, for allowing me to make a brief contribution to this motion, which was placed by our colleague, Senator Anthony Vera, regarding the recognition of the Caribbean Court of Justice as the final court of appeal for Trinidad and Tobago. Madam President, in preparing my contribution, I noted there are more literature and opinions on this topic than I think there are Hansards for the Senate in any given year. However, the literature helped clarify, in some ways, the pros and passion for advocating for the implementation of the CCJ as the final court of appeal in Trinidad and Tobago, and the fears that led to arguments against such a move. Today, I wish to delve briefly into both sides of the argument and offer what I hope would be a balanced synopsis from which hopefully we can arrive at a reasonable conclusion, and one that is in the best interest of the citizens of our beloved country. Madam President, there seems to be a trial being conducted in the public space by professionals and lay people alike as to which is better as the final court of appeal for Caribbean people, the CCJ or the Privy Council. A stalwart of the legal profession, Professor Rosemary B. Antwine, weighed in on this discussion, detailing her views in an article entitled Waiting to Exhale, Commonwealth Caribbean Law and Legal Systems, which was published in Article 3, Issue 2, Volume 29 of the Nova Law Review in 2005. She cited the cost of justice and indigenous jurisprudence as reasons why the CCJ should be implemented as the final court of appeal for Trinidad and Tobago. In an article by Andrew N. Maharaj entitled A Horizontally and Vertically Comparative Study of the Caribbean's First Independent and Interdependent Court, was published in volume 47 of the Cornell International Journal in 2014, and did wonders to unravel just how this issue of cost bears negatively on a citizen's access to justice. At pages 742 and 743 of the article, he explained as a starting point, fixed cost and the cost of filing an appeal to the Privy Council is more than 5 times greater than filing an appeal with the CCJ. In situations where the CCJ deemed filing costs too burdensome on an individual litigant, it has been willing to waive them completely. The Privy Council offers this aid on a much more limited basis. Moreover, the court has implemented a system that would moderate the costs councils can recover from a losing litigant. Madam President, justice should never be seen as only a rich man's entitlement, particularly appealing to the final court of appeal, especially when there's another option by which justice can be accessed faster, good quality, by persons of lesser means, i.e., the Caribbean Court of Justice. Madam President, this option is owed to the citizens of Trinidad and Tobago. At an annual dinner of the Rotary Club of Georgetown on February 24, 2007, the Right Honorable Mr. Justice Michael de Labastide, President of the Caribbean Court of Justice, explained the member states submitted and affirmed the court's jurisdiction by signing and ratifying the revised Treaty of Chaguaramas. This makes the implementation of this court compulsory. More than that, Justice de Labastide stated, this court is also made as an exclusive jurisdiction as well. Madam President, the idea of a unified system of justice, indicative of Caribbean jurisprudence, with an understanding of our intricate nuances and representative of the Caribbean's identity and culture, was enveloped in the construction of CARICOM. The idea was to birth a Caribbean court as part of that whole system. The founders of the Caribbean CSME did it. They succeeded. And the Caribbean Court of Justice was born in 2005. It is the only court in the world that has the authority to interpret and apply the revised Treaty of Chaguaramas. Any legal matter surrounding the CSME must come before the CCJ for resolution. Not only that, but the contracting states also agreed to implement the Caribbean Court of Justice as a final court of appeal in replacement of the Privy Council. This is what I mean when I say access to the CCJ is owed to the citizens. Madam President, today Trinidad and Tobago continues to be in breach of the said agreement. My question is why? I read and I listened to the arguments against the implementation of the CCJ, and the overwhelming concern seems to be whether the justice will be dispensed impartially by this court. Madam President, the CCJ is funded from the proceeds of a trust fund established by CARICOM member states and not the government. Additionally, the judges and staff of the court are selected by the Independent Regional Judicial and Legal Services Commission, and a rigorous selection process is carried out, including background investigation and intensive interviews. Moreover, the judges of the CCJ have a life tenure until the age of 72. Thus, they are able to make decisions without considering their judicial term renewal, one way or another. Appointment of the president of the court is made by virtue of majority vote of 3/4 of the contracting states, and because of this, CARICOM put a safeguard in place directing that he or she may only serve for one non-renewable 7-year term, within which any form of public misbehavior or abuse of the office could be addressed. Transparency procedures were built in to keep the judges accountable. Madam President, the structures and operation of the CCJ seems to have been created in such a way to buffer the possibility of influence. Andrew Maharaj even commented in the same article mentioned earlier, beyond borrowing systems of other courts, the CCJ has created new systems of its own, such as the trust fund, the commission, and the mixed system of judicial tenure. This amalgam of old and new has created a framework poised to build the CCJ into a successful regional court. With the questions regarding impartiality satisfactorily answered in my mind, the next question arises: whether our problem has to do more with an inferiority complex than anything else. Is it that we do not value the intellect of our own people and see the merit in what they have to offer? If that is the case, then I think we must shift our thinking from this ideology that everything foreign is better and everything local is second class. We must display pride for what is indigenous to us. Otherwise, we stymie the progress of our own people. I quote again from Sir Sridhar, who was talking about what was happening at that time in the system. He said, "Do I need to remind you that from our Caribbean shores, we have sent judges to the International Court of Justice, to the Presidency of the United Nations Tribunal on the Law of the Sea, to the International Criminal Court and the International Court of the former Yugoslavia, and of course to the International Criminal Court, International Criminal Tribunal for Rwanda, from which the new president of the CCJ that came after 2 terms of distinguished presidency." Madam President, our jurists in the Caribbean are bright and they can do the job. Why aren't we allowing them to do it? As it stands, most of our legal professionals will never get the opportunity to appear before the highest appellate court and therefore never obtain the learning that can come from practice. Additionally, they will also never have an opportunity to be promoted to sit on the bench as a judge of the highest appellate court for their country. I deem this to be a disservice to our people who have such wealth and treasure of intellect. Another point is to be made. While we are running to the Privy Council, they are suggesting that we do not. Sir Sridath, Chancellor Emeritus of the University of the West Indies, regional statesman and former Commonwealth Secretary General, while delivering the first distinguished lecture to Trinidad and Tobago Judicial Education Institute in September of 2011, and I quote from him, he said, "Our embarrassment in this matter should have been compounded by the observations by the eminent President of the new Supreme Court of Britain, Lord Phillips, deploring how the time of his country's highest judges, now justices of the Supreme Court, will continue to be taken up with appeals to the Privy Council. In an ideal world," Lord Phillips is reported to have said, "former Commonwealth countries, including those of the Caribbean, would stop using the Privy Council. Think of our people stop using the Privy Council and set up their final courts instead. This is what the jurists of the Privy Council think of our people in the Caribbean coming to them as a final court of appeal, literally cap in hand, and as though we do not have something that is as good as theirs, or at least we are seeking to become as good as them." Madam President, I think a part of the problem being faced in Trinidad and Tobago is the challenge in our leadership and how we make decisions. I'm concerned, for instance, the change that needs to be made in our legislation for the Privy Council to be replaced, for the CCJ to replace the Privy Council as the final court of appeal requires both government and opposition support. And so far, this has escaped us. For example, the current opposition leader, when she was Prime Minister, supported the implementation of the court at that time, though in a limited capacity. Yet, even that limited capacity is not yet a reality. Now, we hear dissenting voices from the opposition. What has changed since 2012? Is it because you were in government then and you're in opposition now? Was implementation good for that time, but not for now? If nothing has significantly changed, then let us please make the decisions based on merit and on substance. Our previous leaders signed on to agreement which we need to put into our law books. We should do it now. In her paper entitled "Replacing the Privy Council with the Caribbean Court of Justice in the OECS Countries," Isabel C. Davila stated that the institutionalization of the Caribbean Court of Justice assumes political, economic, nationalistic, and even emotional overtones and is inextricably bound up with the issues of our independence and sovereignty. Madam President, I agree with that statement. Our system should reflect our identity. Trinidad and Tobago cut ties from Britain in 1962, and further ties were cut in 1974 when we achieved Republican status. We now have a new identity as a country, as a subset of the Caribbean region. So why is it that our justice system does not? Madam President, I support the motion. Thank you.
Minister in the Office of the Attorney General and Legal Affairs.
Madam President, I thank you most sincerely for recognizing me in this debate. Madam President, if I may steal a few seconds from the Senate's time, and in light of our tropical cycle number 2 warning, I just want to simply join in emphasizing, Madam President, to the citizens of Trinidad and Tobago, the importance of making the necessary arrangements to ensure their safety and security. Trinidad and Tobago, please, now is not the time for zessing, and certainly not the time for storm parties. Please be safe, Trinidad and Tobago. Madam President, to that end, I want to jump directly into the debate and, add my 2 pence to this very critical and important debate. To that end, I want to begin by congratulating Senator Vieira for always being a forward-thinking independent senator, a senator who's devoid of politics and certainly, in my estimation, a true patriot to Trinidad and Tobago, and someone who recognizes the importance of our growth as a nation away from, in this instance, the Privy Council and our colonial masters. So congratulations, Senator Vieira. So certainly I stand in support and join in the chorus with my other colleagues on the government bench as we add our support to this very, very critical motion. Madam President, the Honorable Patrick Manning, may God rest his beautiful soul, on April the 16th, 2005, on the historic occasion marking the inauguration of the Caribbean Court of Justice, said this, and I quote, "It was the late eminent Reginald jurist Sir Telford Georges who observed that to have independent countries referring legal jurisdiction to their former colonial masters is tantamount to a grown man who demonstrates his independence but continues to live in his parents' house. It is with great pleasure that I inform you that we have now found excellent accommodation and we are moving out." Close quote. Quotation. Today, Madam President, I want to put on the record my support for Senator Vieira's motion, my support to the Prime Minister, Dr. Keith Christopher Rowley, my support to the Honorable Attorney General to fulfill this country's treaty obligation to acceding to the CCJ as our final court of appeal, to replace, Madam President, the Judicial Committee of the Privy Council. The time is now, and I wish to say to Trinidad and Tobago and to the members of this Senate, we have found an excellent accommodation and we are moving out. Madam President, to that end, I want to focus on an article that I found in preparation for this particular debate. The Duke E. Pollard, in his book, Madam President, The Caribbean Court of Justice, and this is the for the purpose of the Hansard, Closing the Circle of Independence, 204, in brackets, 2004, stated, "The establishment of the Caribbean Court of Justice in its appellate jurisdiction will signal the birth of autonomous judicial decision-making in member states of the Caribbean community and close the circles of independence which commenced as early as 1962. In a real sense, too, the establishment of the court will mark the culmination of initiatives to create our own regional institutions to facilitate and promote the development of an indigenous jurisprudence reflective of the moral, political, social, and economic imperatives of our region, and which commenced with the establishment of the Council of Legal Education in 1970. Madam President, to that end, I would like to highlight 2 critical points. Every time, Madam President, a case is before the CCJ and a judgment is delivered, we are aware that these judges are shaping and molding this region's jurisprudence. This is also one of the goals of the CCJ. Madam President, in a paper entitled The Caribbean Court of Justice and the Evolution of Caribbean Development, presented by Right Honorable Sir Dennis Byron, then President of the CCJ, at the 15th Annual Sir Arthur Lewis Institute of Social and Economic Studies Conference in April 2014 stated, one of the aims of the court as expressed in its strategic plan is innovative in the sense of fostering jurisprudence that is reflective of our history, values and traditions and consistent with the international law norms. Madam President, the CCJ in its appellate jurisdiction, as we are all aware, has addressed various issues ranging from civil, criminal and constitutional law, areas ranging from death penalty to labor rights and other human rights areas. The Maestral Armand Claude, in the constitutional functions of the Caribbean Court of Justice, June 16, 2015, in a journal entitled McGill Journal of Dispute Resolution, Volume 1, Number 2, 2015, at page 70, Madam President, states, analysis of the many other decisions of the CCJ under its appellate jurisdiction reveals that the court is indeed marking a highly constructive contribution, not only to the law of the three countries that have accepted its appellate jurisdiction, but also to the Caribbean region as a whole. The impact of its appellate jurisdiction will surely be felt even more as it's gradually adopted by other Caribbean states, end quote. In the same paper, Madam President, I referred to earlier, Sir Dennis Byron, he went on to further say that in the CCJ's appellate jurisdiction, the court has been able to clarify important doctrinal elements even in the Guyanese land law system, which is unique to Guyana, which is unique to our region. So, Madam President, this is one of the many reasons, at least based on the learning that I have presented and the literature that is available, why we stand in support of the development of regional jurisprudence. Adopting and supporting this motion is not a political gimmick. Adopting and supporting this motion is, as I began, the time has come for us as a nation to move out of our parents' home. Madam President, the CCJ esteemed judges are best positioned, in my respectful submission, to understand the realities that we face here in this region, and more specifically in Trinidad and Tobago. Recently, Madam President, hot off the press, as I may say, in an article that was in the newspaper on Saturday, June 25th, 2022, the Trinidad Guardian, to be clear. The article entitled, Ramesh, the people must decide if to replace Privy Council with the CCJ, written by Raphael John Lal. And it stated, former finance minister and law lecturer Karen Nunez Teixeira, who also spoke at the seminar, gave the opinion that it is time the country starts to think about leaving the Privy Council, as it is a foreign institution that does not understand the cultural intricacies of Trinidad, and also the cost to go to the Privy Council is out of the reach of the majority of Trinidad and Tobago population. I am one, referring to Ms. Nunez Teixeira, I am one of those who believe that the time has come to take a leap of faith and to make the CCJ our final court of appeal. So, Madam President, just recent, and that is why I support Senator Vieira's motion, because here we have, even in 2020, conversations continuing relative to the importance of us breaking our ties from the Privy Council and, of course, turning to something that is ours, something that will be uniquely Caribbean, something that will be uniquely regional. Madam President, Chapter 4, page 46 of the Caribbean Court of Justice, an article entitled The Caribbean Court of Justice, The History and Analysis of the Debate, presented by Hugh Rawlings, lecturer in the Faculty of Law, UWI, published in the Caribbean Community 2000 Guyana, this paper states, Madam President, there has been an interesting assertion of justice, that justice cannot be divorced from local circumstances in which a case arises. An essential requirement of this assertion is that the adjudicators should be familiar with those circumstances and ideally should themselves spring from. The truth is, however, that the value which many persons in the Caribbean place on decisions of the Privy Council, as well as their respect and confidence in its administration of justice, is in part incidental to its location, far removed, Madam President, from the Caribbean. So, Madam President, this is an academic debate and has been ongoing for many, very, very many years. As Senator Vieira stated in his contribution, there is much literature on the CCJ, and me being the nerd that I am, thoroughly enjoyed preparing for this particular debate. Madam President, there are so many luminaries, some whose thoughts and contributions I've put on record today. And I took the time to do so to show, Madam President, that there is support throughout the region and locally that the CCJ is best positioned to foster and develop this jurisdiction's jurisprudence because of their understanding of our unique and varied legal matters. So, Madam President, as I get into the crux of my debate, it has been said that the Parliament, of course, it has been said that the Parliament is the highest court of the land. And if that is indeed true, Madam President, that makes you the Honourable Judge and members of this Honourable Senate, ladies and gentlemen of the jury, together with members of the public. So if I am to approach this particular debate as if this was indeed the highest court of the land, my intention, as I would do in any court, of course, Madam President, would be to provide evidence to this court and evidence to the jury as it relates to this particular recital of Senator Vieira's motion. In Senator Vieira's motion, the Honourable Senator said, and whereas the unique and varied legal matters which arise in the Caribbean are far removed and foreign to the society, culture and habits of the Judicial Committee of the Privy Council, as sentiment echoed by the Privy Council judges and senior British legal figures. That, Madam President, is the part of Senator Vieira's recital that I intend to focus on. And in an attempt to do so, I wish to present evidence to this honourable court as to why, focusing on 4 landmark decisions, Madam President, taking this honourable court through those 4 landmark decisions, emphasizing where it was critical for these matters to be tried before a court such as the CCJ, they understanding the peculiarities of our Caribbeanness and what makes us Caribbean. You know, Madam President, just yesterday, and I want to also use the opportunity to offer my sincere condolences to Justice of Appeal, Judge Malcolm Holdip, who laid to rest his 35-year-old daughter yesterday. Ariel, to be was my very, very good friend. And the reason why I'm bringing up Ariel, and I want to read her name into the Hansard, Madam President, is because a very personal story. Ariel walked and was at my side throughout the length and breadth of the 2020 general election. She stays separate and apart from politics, but I'm her friend, so she supported me. And during that election, it was the first time I exposed myself to the public. And during the course of that election campaign, Madam President, on several occasions, of course, there would have been the trolls who attacked me based on the fact that I was too fat. There were those who attacked me on my eyebrow and my makeup. I talk about attacks. And I recall on one occasion during the election campaign, I went to her and I was in tears and I said to her, I can't take this anymore. Like, stop posting pictures of me because people will continue to talk about how fat I am. And this friend of mine said to me, she said, be your unique self. She said to me, be your authentic self. Do not allow anyone's perception of you to change who you are. And why I bring up that concept, why I bring up that idea of authenticity, Madam President, is because when we look at the Caribbean, we are indeed an authentic region. We are indeed an authentic nation. And I believe it is critical as it relates to our law because of how authentic we are. It is important for us to adopt the CCJ as our final appellate court because we will have judges sitting there who understand the peculiarities and the authenticity of us as a people and of us as a region. So, Madam President, as I indicated, my focus in this debate would be somewhat academic, in which I would focus on 4 decisions coming out of the CCJ, in which I respectfully submit to this honorable court, to this honorable Senate, to the people of Trinidad and Tobago, that had these matters been tried before the Privy Council, we may not have had the decisions we had coming out of these decisions. Reason being, the CCJ better understood our peculiarities, better understood our authenticity as a Caribbean people. Those decisions, Madam President, firstly is the case of Katrina Smith versus Albert Anthony, Peter Selby. It's a 2017 case, CCJ 13. Then there is the case of Ramdas versus Jairam and others, CCJ 2008 case, CCJ number 6. Then there is Maya Leaders Alliance versus the Attorney General of Belize, a 2015 decision, Madam President. McEwen 2018 CCJ case. These decisions, Madam President, which to my mind focus on certain unique aspects of us as a Caribbean nation, because these are cases spanning from Guyana to Barbados to Belize, different jurisdictions in which we required, which I respectfully submit, Madam President, having judges who understood the Caribbean identity and our, as Senator Vieira eloquently puts it in his recital, understood the unique and the culture, the society and habits of our Caribbean people. Now, Madam President, I may respectfully begin with the case of Katrina Smith versus Albert Anthony. Now, the facts of this case, Madam President, and in looking at these cases, for us to understand why I'm putting this on the record, I would be required to go through the facts, the issues and the law and analysis of these cases. Because, of course, by the time I get to the law and analysis, we will understand what the court took into consideration that was so uniquely Caribbean that allowed them to make a particular decision. Now, Madam President, in this particular case, this is a Bajan case. It came out of Barbados. The facts of that case, the deceased Albert Selby died intestate, and for the non-lawyers amongst us, he died without a will, which meant that his estate had to be administered in accordance with the Succession Act and the rules of intestacy. The deceased, Madam President, had no children, was predeceased by his parents and survived by his siblings, including the respondent, Mr. Albert Anthony Selby. The deceased was an unmarried man at the time of his death. However, he lived together with the appellant, Miss Smith, a man and woman, for more than 5 years, since April 2000 until he died. Now, Madam President, on the case reads, on the 6th of August 2020, the Court of Appeal Barbados declared Miss Smith as a spouse. However, the respondent, being the deceased brother, appealed against the ruling. When the appeal was heard on the 14th of January 2016, the Court of Appeal reversed the decision that Katrina was the spouse of the deceased, was not the spouse of the deceased, whereby it rejected the decision of the trial judge that the word single in section 2 subsection 3 of the Act included a married man who was separated from his wife, and rejected also the alternate rationale that the term single was descriptive of a status of the parties had at the death of the deceased. Now, the issue coming on, and this is just the bare bone facts, the issue in this matter that the court had to determine, Madam President, was whether Miss Smith who had been living with Mr. Selby as a man and wife immediately preceding his death was his spouse as defined in section 2 subsection 3 of the Succession Act, chapter 249 of Barbados, which prescribe that reference to a spouse includes a single woman who is living together with a single man as his wife for a period not less than 5 years immediately preceding the date of his death. So this matter, when it went to the appeal, as I said before, it was a matter really that required interpretation of the law. The controversy of this matter, Madam President, centers on the issue of whether the deceased was a single man immediately after preceding his death. The controversy in this case, Madam President, is derived from the view that there is a rigid distinction between literal and purposive approaches to the interpretation of the statutes. Now, let me turn to the law and the analysis. The CCJ, Madam President, in this matter had to examine the principles of statutory interpretation of the Bajan Succession Act, adopting and applying Lord Bingham dicta in the case of R versus Secretary of State for Health on the West Indian law reports, where it was held that the principles which the judges must apply when interpreting statutes included respect for the language of the Parliament, the context of the legislation, the primacy of the obligation to give effect to the intention of the Parliament. The CCJ decided, Madam President, that the primary function of a court was to give words the meaning Parliament intended and was discerned by understanding the objective of the legislation, the change that it was aimed at producing and its purpose. Now, Madam President, the CCJ looked at another case, Hayden's case, which is still relevant today, and highlighted that it is the duty, Madam President, of a court to consider the mischief and intended remedies which made it necessary to pass legislation and to add force to the intended cure according to the intent of Parliament for the benefit of its people. Now, the CCJ also considered comments from academics in its interpretation exercise about the social and this was actually found in the obiter dicta, the obiter comments of the case. So the CCJ also considered comments from academics about the social and historical context within which the act was enacted and found, Madam President, that the act was a social legislation, to address one of the realities of a Caribbean society that had not been reflected in the common law or statute inherited or adopted from England, whereby persons living together as man and wife but were not married to each other and their children had not been recognized in the colonial legal and judicial regime with unfair results. Therefore, the right to inherit was dependent on the status of marriage. In this case, Madam President, the CCJ noted that on the death of a partner in a non-marital union, in the absence of a will, the survivor had no right to inherit or otherwise benefit from the deceased's estate, regardless of the quality or duration of that union. Conversely, a person who was married to a deceased could inherit regardless of the quality or the duration of the marriage, whether it's an empty shell marriage or not. Based on the law, you were entitled, pursuant to that archaic colonial law, you were entitled, Madam President, to benefit, whether the survivor and the deceased had been living at the time of death in another non-marital union. And as we say, local parlance, whether it was horned in or not, and you had an outside relationship or not, based on that archaic law, you could have benefited. So the CCJ in this case, in looking at the social circumstances, said we will not have it, in essence. We will not have it because the reality, as we know in the Caribbean, there are many common law relationships in which man and woman live better than married husband and wife. And the CCJ, in understanding our unique realities, understood that it was important to give recognition to women and persons in Barbados who lived in this kind of relationship. Now, in conclusion, Madam President, the CCJ reviewed Section 2.3 of the Succession Act, 249 as a whole, and found that Section 2.3 changed the definition of spouse for the purpose of inheritance under the Act to include a single person who was not married to and who cohabitated with the deceased for 5 years immediately preceding the death, provided the deceased was not married to someone else. The court, Madam President, decided that the mischief the Act intended to remedy and the solution it prescribed, meaning the CCJ, were clear. The right of the survivor of a non-marital union to benefit from the estate of the deceased partner was not dependent on the status of the marriage, but on the duration of the cohabitation with the deceased immediately preceding death. In this case, the statutory period of cohabitation for 5 years immediately before the death of the deceased was determinative of the right to inherit as a spouse, as this could have been used as a credible indicator of a commitment to a true union comparable to a formal marriage. So, Madam President, I particularly, having practiced in the family court and having had to deal with so many women who would have come to me who had cohabitational relationships and who were told by their spouse, their cohabitational spouse at the time, that you wasn't getting a thing because you was never married to me. One can imagine how pleased I was when I was in practice to know that this was the kind of learning that was coming out of the CCJ, a court that truly understands the peculiar, and I started by saying the authenticity of us as a Caribbean people. So this is one of the cases that I've presented to this honorable court with the hope that at least when it comes to voting on this motion, we would be able to do so, understanding that this case, that the CCJ has played a critical role in developing our jurisprudence, yes, but more so, it is best positioned to make said decisions, because what we would have is our own people, Caribbean brothers and sisters, Caribbean luminaries sitting there, called upon to make a decision. And mind you, this is not an emotional, because I know the opposition in the previous debate spoke about this as in speaking about Senator Vieira's opening statement, spoke about, this is not an emotional debate. But we have to, unfortunately, in this debate, we have to put some emotions in it. And we have to understand that the CCJ would be best positioned, as I said before, based on understanding our unique Caribbeanness to make certain decisions. Now, as I would have indicated in my introduction, Madam President, throughout the course of this contribution, I would look at cases. The other case that I want to turn to, Madam President, is the case of Ramdas and Jairam and others, CCJ 2008. This is a Guyanese case. And again, the part of Senator Vieira's recital that I would be focusing on is, and whereas the unique and varied legal matters which arise in the Caribbean are far removed and foreign to the society, culture, and habits of the Judicial Committee of the Privy Council, as sentiment echoed by the Privy Council judges and senior British legal figures. Now, in this case, again, if I may respectfully take this Honourable Senate through the length and breadth of this case. Madam President, generally, the facts of this case. The appellant, Ramdas, and the first respondent, Loki, were brother and sisters. Loki inherited land from her husband and had agreed to sell to her brother 36 acres for the sum of $30,000. Subsequent to this, Madam President, Loki also entered, for the smart manism that is also uniquely ours as a Caribbean people sometimes. Loki also entered into an agreement of a sale with Ali Mohammed, under which she sold for the sum of $125,000 all of the land which she had inherited from her husband, including the 36 acres which she had earlier sold to poor Ramdas. This resulted in litigation, Madam President, when Ramdas was granted an injunction by the court restraining Mohammed from entering his portion of land. In his pleadings, Madam President, Ramdas alleged that Loki and Mohammed fraudulently passed transport, because that's what transfers are referred to in the Guyanese jurisdiction. It's not referred to as a deed, it's referred to as transport, to Mohammed in order to defraud him of property. Ramdas filed action against Loki, Mohammed, and the Register of Deeds, seeking specific performance of his agreement with Loki and revocation of Mohammed's transport. In essence, the revocation of Mohammed's deed based on fraud. Now, the issue in this particular case, Madam President, raised was whether equitable interests in land in Guyana are recognized or can be acquired having regard to the development of the law of immovable property in Guyana, particularly in relation to a purchaser who is put in possession under an agreement of sale. And immovable properties are like chattel houses that we are aware of, that is so unique to the Caribbean as well, right? Now, let's turn to the law and analysis in this particular case. Guyana, Madam President, has a hybrid land law system, and for those who would have practiced in other jurisdictions, I would understand, or even just through law school, because I have not practiced in Guyana, but just in going through law school and having Guyanese friends, you understand that their land law system is a mixture, Madam President, of the Roman Dutch law and English common law, which is unique and by far more complex than, I believe, any land law system that exists in the entire world. Now, so complex in its own right. In its appellate jurisdiction, Madam President, the CCJ has been able to clarify important doctrinal elements of the Guyanese land law, offering clarity, legal certainty, and stability to the Guyanese community on many of these land issues, and Ramdas and Jairam being one of those cases. Now, the court in this case, Madam President, would have had to examine Section 3 of the Civil Law of Guyana Act, Chapter 601, subsection B, which states, the common law of Guyana shall be the common law of England at the time, the date aforesaid, including therewith. Well, you know how these things are drafted. The doctrines of equity as then administered or at any time hereafter administered by the Court of Justice in England. And the High Court shall administer the doctrines of equity in the same manner as the High Court of Justice in England administers them at the time aforesaid or at any time hereafter. So that is an excerpt actually taken from Section 3, subsection B of the Guyanese Civil Law, the Civil Law of Guyana Act. Now, subsection C of that same section, so we have section 3, subsection B of that same law states, the English common law of real property shall not apply to immovable property in Guyana. And then it goes on to say in subsection D, there shall be as heretofore one common law for both immovable and movable property, and all questions removing to immovable property in Guyana and to movable property subject to the law of Guyana shall be adjusted, determined, construed, and enforced as far as possible according to the principles of common law in England applicable to personal property. So here we had wholesale in the Guyanese, in this particular act, Section 3 of the Civil Law of Guyana Act, adopting and mandating legislatively that once cases in Guyana, so I mean irrespective of how unique your case was, if you relied upon the law to the letter or the law that was on the books, decisions could only be made based on what happened, how the British would have applied the law in their circumstances. So this, in essence, was the janjat that the court was faced, the CCJ was faced when this case came before it. Therefore, through this provision, it is provided expressly, Madam President, based on what I just said, that the English common law of real property was not to apply to immovable property in Guyana, and that there was to be one common law for both immovable and movable property, meaning chattel houses, with the proviso that immovable property may be held in full ownership, which shall be the only ownership of immovable property recognized by the common law. Now, the concept, Madam President, as I indicated before, of chattel houses known to the English law, notably in the case of Ellingstone Limited versus Morris, which questioned whether a bungalow situated on top of concrete blocks but was not attached to them form part and parcel of the land itself. This is a peculiar phenomenon in the Caribbean society, and most Caribbean territories have given it statutory recognition. It was held, Madam President, in Ellingstone that it cannot be removed without being destroyed, then it is more than if it cannot be removed, without being destroyed, then it's more than likely a fixture. Now, therefore, though the judges, Madam President, of the Privy Council, in this particular case, though they understand the concept of chattel houses, which is still existing at the and is very common to us in the Caribbean, there are key societal issues unique to us, Madam President, to consider arising out of the issues of chattel houses.
Minister, you have 5 more minutes.
Thank you, Madam President. Arising out of the issues of chattel houses, movable properties which they may not appreciate and relate to, such as fraud, such as land grabbing, such as bribery and collusion. It must further be noted that certain aspects of the English law will not reflect on our needs, cultural traditions, and regional objectives. Through the CCJ, Madam President, we can be proud as a region that the people of the Caribbean region will now be placed in a position to take control of the administration of its own justice, as has been the case in relation to other aspects of our regional responsibilities. Madam President, a prime example of land fraud occurring in Trinidad and Tobago is the Caroni 1975 land issues surrounding fraudsters and people offering deals for sale, which we are dealing with as a national and regional issue, especially in relation to unregistered deeds, which are deemed to be fraudulent and void. With this in mind, Madam President, I ask the simple question: can a judge in the Privy Council fully understand and have an appreciation for culture and determine whether a chattel house on blocks in a community in Georgetown, Guyana, belongs to the occupant or the owner of the land? And my answer to that, Madam President, is no. Madam President, or can judges of the Privy Council appreciate and knowledgeably determine matters related, let's say, to Susu that exist in Trinidad, which have been common, especially in rural communities in Trinidad and Tobago? My answer to that is no. Actually, preparation for this particular matter, I saw that there was a matter some time ago, I think it's in Princess Town, where a lady brought a matter for obia against her neighbor for practicing obia. And that was actually the case. It's a matter based on obia. I remember when I was practicing law, there was actually a counsel, and of course I would not mention his name, who said he had to run, it was a murder trial, and was attempting to run a defense based on obia, that the man got shaft from a obia man. And therefore when he was acting in a, I'm sorry to laugh, but he was acting in a particular way because he was under the influence of obia. You can imagine case. Now, of course, in the UK, they have dealt with witchcraft, but that act that dealt with witchcraft, I understand, has been repealed, and so therefore there's no law at all in the UK that deals with the issue of witchcraft. But in our Summary Courts Act, even in Trinidad and Tobago, there is recognition to issues of, for want of a better word, obia matters. So, Madam President, all that being said, I know time is against me, and unfortunately, I do not have the time to go through the other cases that I intended to put on the record.
Senator Nakid, just 1 second. Senator Nakid, please apologize for that statement. Please rise and, yes.
Apologies,
Thank you. Continue, Minister.
Thank you, Madam President. So I don't know if certain people in here under OBIA too, they're acting enough. Anyway, I'll move away from that. Madam President, the point that I want to make most respectfully is that, of course, I stand in support of Senator Vieira's motion, recognizing that we are peculiar and we are authentic as a people. And as the then Prime Minister Manning said, the time has come. We have found an excellent accommodation, and like it or not, we are moving out. I thank you, Madam President.
Senator Roberts.
Thank you. Thank you, Madam President. It's indeed a pleasure to follow the learned attorney and the minister in the office of the Attorney General. And I see that she just finally made a case by bringing up OBIA for the Honorable Prime Minister now to probably head the CCJ. But I heard the Honorable Senator
Madam President, on a point of order, the Senator is imputing improper motives against this Senator by saying that she is bringing forward a case of OBIA for the Prime Minister.
Senator Roberts, please continue.
Thank you, Madam. Oh, my goodness. Yes, but the Honorable Senator spoke about emotion and said that Senator Vieira brought in emotion and the CCJ evokes emotion. Let me agree with that, because when I was listening to the Honorable Independent Senator Vieira, and he was talking about passionate about patriotism, about believing in ourselves and knowing that we can chart our destiny and so on, I actually started to feel that, because I too believe in that. I agree that we in Trinidad and Tobago can achieve greatness in any sphere, wherever we set our minds to. In fact, I have been part and parcel of that in Olympic swimming in Trinidad and Tobago for the last 35 years. So I certainly do not share the belief of Independent Senator Remy that if I do not support the move to the CCJ, that somehow I am unpatriotic and I do not believe in the brilliance of my people, because I certainly do. So therefore, that argument will be a non-starter. So while we get emotional, we must understand that this argument is a very critical one. And our last speaker, the Honorable Senator and Minister in the Office of the Attorney General, gave us some good cases, some interesting cases, where the CCJ, due to their culture and their understanding, gave some brilliant, adjudicated brilliantly on certain matters. That's not the issue, however. We are not here to determine whether the CCJ and our learned judges or our people are qualified to sit in a court, or whether the Privy Council, it appears from the last argument that if you don't eat roti, you will not be able to hear an argument on the curry powder utilized to produce a good beef roti. Because it is quite clear that no matter what the court, lawyers, attorneys, learned people who get briefed by their clients go to these courts and make arguments. What is clear and what is the point that we need is that how are these arguments heard? Through what sort of ears? What sort of filter? The problem in Trinidad and Tobago and the Caribbean is that unfortunately, after 62 years of independence, our societies are small, and we tend to agree with the founding father of the PNM, Dr. Eric Eustace Williams, who, when he brought us to independence, left the Privy Council because he said Trinidad and Tobago is a small place. Everyone knows everyone, and everyone exists and attends cocktail parties. And that's the essence of our debate here. Is it possible, is there evidence in our judicial history that political interference can infiltrate a court and lead to decisions that may not be in the best interests of the nation, or may be tainted by bias? I am surprised that the Honorable Learned Attorney Minister in the Office of the Attorney General did not quote a case from yesterday. I thought she would go there and try to convince me that that Privy Council judgment, which I would go into and analyze shortly to make my point, show me where, why, and how the CCJ would have been a better place for that case and that judgment that was just handed out by the board of the Privy Council. I understand Susu and different intricacies of land, and that's very good. No one here is coming to make an argument that our people are unqualified. We are making a case that we need and must hold on to the Privy Council because the very essence is that they are separated by the Atlantic. And in that Atlantic Ocean and that distance comes some impartiality, fairness, and listening without the veneer of red or yellow. And therefore, justice can truly be blind and justice can be fair and impartial. That's the argument. So the mere fact that the PNM, the People's National Movement, is clamoring for the CCJ is actually an argument against the CCJ. The mere fact that we are seeing and hearing about the culture of Trinidad and Tobago, I take honorable members back to an article printed in the Newsday, July 28, 2014, because if you want to talk about culture, we must be realistic about all our culture, positive and negative. There's an article in 2014, July 28, where a report was done by then Registrar of the Court, Mr. Jackson, in which he complained of a myriad of issues going on at the CCJ, one of them being about our culture. Because as you all know, we in this August House and many in the lower house, we get, during Carnival, we celebrate, and whoever's in government, we get VIP tickets and so on. That's the norm. But a judge in the CCJ instructed his driver at that time to sell these tickets. The driver, printed in the Newsday, decided and thought that that was unethical. So he told the honorable judge, no, I won't do that. That is for you and your wife only, and they are non-transferable. He was fired. And then another driver was allowed to be hired at $1,300 US. This is the problem. And understand that when we have this sort of infiltration into a court, we must be very careful, especially in cases that may involve politics. As Dr. Williams said, all of us are so close together that politics impacts everything, and politics can warp judgment. Mr. Jackson also went on to report a litany of woes.
Senator Roberts, I have to caution you here. I just caution you to Standing Order 46.8, which speaks about bringing the conduct of members of the judiciary, and by extension, it'll be the CCJ, into this debate. So I'll have to ask you to veer away from this line that you're pursuing.
On one judge. So thank you, Madam President. But the report was also discussing the general administration of the CCJ. Is that okay? I didn't ask.
Senator Roberts, I will ask you, please, to whatever that report is, and just because it's a report does not mean that you can come here and speak about it. So I've given you the warning. You can continue, and I will caution you as you go along.
Thank you, Madam President. What I'm saying, I won't go on, but to come here and pretend that everything Caribbean, and because it's of us, and we are proud of ourselves, to blind ourselves and to dip our head in the sand to suggest that all of our institutions are functioning well is to really go down a dangerous path. In Trinidad and Tobago, part of our culture is to understand that independent institutions have a track record and a history of being tainted by politics. So we must be careful, especially when handling the judiciary, because that seems to be the last bastion of a place where citizens can feel rest assured that somehow when they argue and they make their case, that a fair judgment will come. It's not perfect. Nowhere in the world is it perfect. But in all of our institutions, it is the one place that we could feel confident. And therefore, when handling it or making decisions, we must thwart our emotions and go to facts, realities, and information. Independent Senator Remy said that the member for Siparia, when she was Prime Minister, wanted to move towards the CCJ in a limited application. But the Honorable Senator failed to tell us what was that limited application. It was in matters of a criminal nature, because our history and our culture would show that in criminal matters, there is less affinity or less possibility of political interference or political influence or political benefit to be accrued from these decisions. So therefore, agreeing and understanding that our learned legal professionals are of the highest order, the Honorable Kamla Prasad Bisesa, on the 50th anniversary of our independence, was suggesting a move towards limited utilization of the CCJ. So to come here today and cast aspersions on the Honorable Leader of the Opposition, saying that she has changed her position because she's not Prime Minister, was a bit unfortunate. So I will move on from that. The Honorable Senator also spoke today highly of merit and said that we deserve merit and so on. I totally agree. But once you stand for a principle of merit, you have to stand all the time for merit. You cannot have a selective morality when it comes to merit, because the exact same senator did not believe in merit when we called the Electoral College to discuss merit. She was not...
Senator Roberts, you are going along a line that I will ask you to please desist. All right? And you are responding to statements made in this debate, but I would ask you not to be making any of the senators who have spoken the focus in that sense. Okay?
Yes, ma'am. I'm just responding to some little points and moving on quickly. The mere fact that this motion came from the independent bench is worrisome, because it should not come from an independent bench, because the independent bench...
Senator Roberts, again, I have to caution you, because you are you are imputing certain things, and I would ask you not to do that. Anybody is free to file whatever motion he or she wishes to file. So I will ask you to move on from that point, please.
Madam President, I'm certainly not imputing anything on any senator. I'm making a general point as stated in the ruling of the Privy Council, paragraph 72, in Dominic Suraj versus State, where the Privy Council said that a special majority legislation should not be required in all cases, because it would give a veto power to a minority of the unelected members of the Senate. So the Privy Council said that the Constitution is selected by the people, and if it is to be removed, it ought to be done so by the people, by the duly elected representatives. And it is in that vein that I am saying that the constitutionality, something so serious, needs to come when some people like politics or don't like politics. Politics represents the will of the people. The PNM is the government now because the people voted for them. The UNC is the opposition because 309,000 people voted for the UNC. Independent senators have not been elected. They have been selected. So that was my simple point. There are a myriad of problems faced by the judiciary in Trinidad and Tobago. Everybody knows it. The attorneys here know it better than all of us. Understaffing, lack of funding, inordinate delays, archaic records, lack of suitable accountability. And this leads to justice being delayed, and justice delayed is justice denied. Yet we are here to debate whether to abolish the Privy Council in favor of the CCJ. We have many other problems in our judiciary to handle before we come to spend all of this time. The people need to feel secure in Trinidad and Tobago, to believe in the total and complete impartiality of the justice system. Unfortunately, the judiciary in Trinidad and Tobago is rotting from the poison of Balize juice.
No, Senator Roberts, please. I already cautioned you on the particular and relevant standing order. Please don't let me have to do it again, okay?
Thank you, Madam President. I see there's a lot of screams over there. But if we look back, when we're speaking about politics and political interference, is it a mere coincidence that in our history of a two-party system, that the people who have been brought before the Court of Appeal who were politicians or politically aligned and were charged and brought forward and eventually freed by
Senator Roberts, you are casting aspersions on the administration of justice, and I will ask you, please remember I have spoken to you about the standing order, okay?
And I would just say that the following people who were unfortunate enough to go through our court system here, but were vindicated by the Privy Council, include Satnarayan Sharma, Bastio Pandey, Finbar Ganga, Brian Kwaitong, Danraj Singh, Vijay Naran Singh, Tim Gopi Singh, and Ish Galbaran Singh. I cannot sing because I got thrown out of the choir, but that leaves it right there to be said. All of these were UNC, most East Indian, all vindicated
Madam
by
President,
the...
Madam President.
No, it's fine. Senator Roberts, you are going down a road that you... No. And please, this is my final warning to you. I cannot warn you any further because I've been doing it too often. So I will ask you, please, desist from this line that this course that you're pursuing. Please.
Madam President, while I hear you, the course that we are debating here, and we are discussing a very serious matter. It's whether we are going to believe in the culture and feel that all citizens will be confident in the CCJ being the final court of appeal, or whether the Privy Council provides some of the citizenry with added comfort about the possibility of impartiality in the judicial system. And I put it to you here that all of these people were vindicated by the Privy Council, and therefore they would feel comfortable that the Privy Council is able to hear arguments, hear legal arguments, take facts, and come to an impartial decision, and therefore the Privy Council should be maintained so that all the people in Trinidad and Tobago can feel secure. This is a debate. This is not here, this is not politics, this is not an emotion, it's just not simple red and yellow. It's a debate. I am providing facts. I am providing a different side that some others may not see, because, as you know, our eyes and ears are always colored by our politics. So some may not see. So if you listen now, you can hear the other side, the other half, and maybe you may change your desire and your decision. That's what a debate is about. Senator Vera stated that there's no history or evidence of political interference in our judicial system. I wish that was so, sir, but I just told you so, right? I wish you were right. So we move on. There's many cases that if you look and you read the judgments and understand the UNC versus the EBC in 2015, the Mahasaba radio license case, one would wonder what's the big deal about? Why not give people a radio license who go through the proper process? But when you read that and you go through the appeal stages, you'll be shocked. But they had to go to the Privy Council, and what happened in the Privy Council? Vindication. This is very important. When we read, for example, and in the Newsday, all of a sudden, the Newsday got it correct. And it was a very good editorial on Tuesday, June 12th. I won't read the headline because it's unnecessary. But the key part was that they were discussing conflict of interest. Okay? And they brought it down. And when you read this, you understand how apparent bias is a very real thing. And it does not have to be actual bias. Okay? It was enough in the case of, it was enough for the Lord Chief Justice of England, Lord Hewitt, in 1923 to quash the conviction, saying, it is not merely of some importance, but it is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. Lord Hewitt added, nothing is to be done which creates even a suspicion that there has been an improper interference with the course of justice. Very important.
You're giving us
Yeah, Newsday editorial, Tuesday, June 12, page 12. Okay? I can give you it after. So, when we see this, we have to understand that in Trinidad and Tobago, politics is involved in everything. And our judiciary has maintained and stood firm and can be a bastion of fairness and impartiality. And we must be very careful. Part of that process is the board of the Privy Council. And to remove that without really understanding all the feelings of the citizens and the people will be irresponsible. We must remember, for example, while we espouse the virtues of our judicial officers, in Trinidad and Tobago, we heard a learned judge, when he moved to a different place, state that it does not matter whether something was real or existed in the case of emails, but the contents of that which did not exist needed to be investigated. Now, any logical, reasonable human being will say that is the most ridiculous, ludicrous position ever uttered. But this was uttered. We then have to ask ourselves, why would a learned individual claim that something that did not exist, it's irrelevant? We must investigate the contents of that which did not exist. What would make a human being reach that illogical conclusion when one would consider that to reach where that learned judge had reached, he had to be very intelligent, very disciplined, passed exams, and had a world of experience. And I put it to you that that is the taint of politics. And we have to be very careful. We have to protect our people from that. Let me move on. All right. Now, this is a case that I would have liked the Honorable Minister in the Office of the Attorney General to analyze for me, because this one is fresh. This one is part and parcel. This one is the essence of that of which we are talking. And if she came here and analyzed that judgment and showed me, I would be willing to listen and understand how the Privy Council should be eliminated in favor of the CCJ. But right there on June 27th, we have the board of the Privy Council in the case of John Henry Smith, who is now deceased, and another, versus the Attorney General of Trinidad and Tobago and others, judgment delivered on June 27th, 2022, unanimously delivered by Lord Judge, Lord Hodge, Lord Sales, Lord Legat, Lord Burrows, and Lord Malcolm. This judgment is critical because it involves a case of which we are speaking. The cases that have politics in it, whether one side is in government or another, is irrelevant. What we are saying is we must guard against the taint of politics. When we see in this Piaco case, corruption case, that was quashed on the 27th by the Privy Council, in paragraph 86, the Lord Justices, the Privy Council, the board unanimously stated, when all the various sources, now one must realize, this case had been argued through our system, our intellectuals, our brilliance, our best, and yet the Privy Council saw it obliquely opposite.
Madam President, 46.8, please, and there are connected matters to that matter as well, presently ongoing.
Senator Roberts, I will allow you to continue, but I'm listening. Just remember my previous caution to you.
So the board of the Privy Council stated, when all the various sources of concern are considered, together the observer would be likely to agree with the appellant's submission that by January 2008, the then Chief Magistrate was hopelessly compromised. This is what we have to protect against. And in
46.8 again. I think we're bringing the judiciary into...
I have allowed Senator Roberts because some of what he's speaking about is on the public record, and I am carefully monitoring what he's saying to make sure that it doesn't go beyond what has been on the public record. Okay?
Thank you, Madam President. Let me make it clear to the population at large. There is no pleasure. I am not trying to bring the judiciary into any disrepute. In fact, in Trinidad and Tobago, it may be the one institution where everyone could get a fair shake most of the time. So let us deal with the issues and let's not run and hide from it, Madam Minister. This is a judgment that I'm sure that you read, which was recently delivered by the board of the Privy Council. We are debating a very serious motion that says, should we get rid of the Privy Council, instead replace it with the CCJ. So please. So I move on. In paragraph 85, the board of the Privy Council said the above is sufficient for allowing both appeals. The constitutional claim succeeds because a tribunal which is seen to be impartial is part and parcel of both due process under Section 4 and a fair hearing in terms of Section 5, speaking about our Constitution, the Constitution of Trinidad and Tobago. However, as will be apparent, if there were any doubt on the matter, the observer would have a number of other important issues to assess. They would include the absence of any reasoning for the Chief Magistrate's dismissal of the recusal application and the transparent attempt to avoid scrutiny by labeling it as frivolous and vexatious. Here's a critical point, because one would always say that when you are making an argument, you must not be afraid. You must listen, hear, and rebut. When someone has to say, do it my way, it's the highway, and cannot explain, it means that the decision cannot be based on facts and reasoning. It is based on emotion. And when emotion is evoked, one could tend to read that politics or some other influence is taking place. And this is very important. In paragraph 83, they said, and this is dealing with apparent bias and actual bias, the Lords agreed. Similarly, in paragraph 104, it is suggested that the appellants failed to demonstrate that the observer would conclude that the Chief Magistrate was predisposed to determine matters against the appellants or their co-accused. In recognition that actual bias is usually difficult to prove, no such demonstration is necessary, merely that there is the real possibility that the judge lacks impartiality. Go back to Dr. Williams, because the PNM today is arguing against Dr. Williams. This was his point, that even though he understood the politics and he wanted to be in power, and some people like myself may say he wanted to control institutions, at least at this point he knew that the judiciary must be left alone. The judiciary must be as impartial as possible. Maybe he understood that the process was slow and that political benefits would have accrued before any real judgment, but he was against removal of the Privy Council. So I need some of the PNM today to tell me why they disagree with their founding father. In paragraphs 81 and 73, paragraph 81, they said, and this is very important, but here, for all the reasons given on behalf of the appellants, the connection is plain and obvious. Look at the language, listen to the words. If something is plain and obvious, how come we got it wrong? You have to answer that, because it's plain, it's obvious, but yet we got it wrong. So something intervened. What that is, I don't know. That's for you all to decide.
No. That is where Senator Roberts, I have to intervene here. That conclusion that you're drawing, you're casting aspersions. I will ask you, please, when you are reading from the judgment, fine. But when you put that particular slant on it, you're imputing improper motives.
President, I am guided. Thank you. But here, for all the reasons given on behalf of the appellants, the connection is plain and obvious. It follows that the board does not accept the Court of Appeal's view in paragraph 97 that the appellant's case on apparent bias involves an extraordinary degree of speculation. In paragraph 73 of the judgment, it states, no doubt there may be cases where circumstances peculiar to the particular country, Madam Minister, from which the case comes, perhaps local customs, attitudes, or conditions, are of direct significance and are matters which the local courts are better placed to assess than the board, which is the argument made by the Honorable Minister in the Office of the Attorney General. Granted. However, no such factors are in play in the present case. Indeed, Counsel's submission on this matter never progressed beyond a high level of abstract generality, yet we got it wrong. So while there is a basis and a solid argument for cultural understanding, heritage and culture, we must also understand that you must find a balance. My goodness, 2 minutes, I could go for another hour. We could find a balance between culture, arguments, decision-making, but the overriding factor must be impartiality. It must be. You see, sometimes you sit on that side and you think you'll be there forever, but you will not. And you need to understand that we must make laws that are fair and balanced throughout, and must not make way for anyone who may not be as honorable as some of the senators here. So we have to be very careful. In paragraph 77, it states unanimously, given the lengthy recital of the background circumstances, it will be apparent that by now that there were numerous potential causes for concern, numerous, concentrating for the moment on just one of them, namely the Chief Magistrate being beholden to the Attorney General by January 2008, and in particular, after the Mustill inquiry revelations, it was clear that no benign construction was available in respect of his receipt and banking of $400,000 by then the full extent of his indebtedness to the Attorney General could be appreciated. It is not difficult to imagine his gratitude. He had the Attorney General to thank for resolving his serious financial problems and for shutting down an investigation into his reprehensible conduct. I put it to you that this could not ever occur with the Privy Council. We don't have that connection.
Mr. Roberts, the adjournment is being sought.
I wish to move the adjournment. Having regard to the agreement by all three benches, we will end today's debate at 3:45, given that storm warning number 8, orange alert, remains in effect. And therefore, with that in mind, Madam President, I beg to move that the Senate do now adjourn to Thursday, 30th June 2022 at 2:30 p.m., when, as I had indicated before, we will debate the National Insurance Amendment Bill. And may I always also remind this Honourable House that we would meet on Monday, 4th of July at 10 a.m. to discuss the bail, to debate the bail amendment bill, and following from that, Wednesday, 6th July at 10 a.m. to debate the Private Security Industry Bill 2022 and the Supplemental Police Amendment Bill 2022. Thank you.
Honourable Senators, the question is that this Senate do now adjourn to Thursday, June the 30th, 2022 at 2:30 p.m. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Thursday, June the 30th, 2022 at 2:30 p.m.